All rise. Honorable court's in session, could be seated.
Good morning, everyone.
Good morning, Your Honor. Good morning, everyone. The matter before the court is Commonwealth versus Gary Zerola on docket number 2184 CR 00072. This matter is here for sentence imposition. Mr. Zerola is present, represented by counsel. If I could have the parties identify themselves, beginning with the Commonwealth, please.
Your Honor, good morning. Ian Pollenbaum for the Commonwealth.
Thank you, Attorney Pollenbaum.
Good morning, Attorney Joseph Krowski Jr. on behalf of Mr. Zerola.
Thank you, Attorney Krowski. Good morning, Mr. Zerola.
Good morning, Judge James.
Thank you, sir. Commonwealth, do you move for sentencing?
I do, Your Honor.
I'll hear you. First and foremost, are there any victim witness statements or a statement from the victim here in court today?
There is not an in-person statement. There is a statement from her that I'd like to read during my comments.
I'll receive it.
May I use the podium, Your
You
Honor?
may.
Your Honor, as the court knows from the Commonwealth sentencing memo, the Commonwealth urges a state prison sentence of 9 to 13 years in this case. That is more than the baseline suggestion of the advisory guidelines, which the baseline for somebody with no prior record is 5 to 7.5 years.
I've had the guidelines run. I have them.
Although, as the court knows, those guidelines contemplate upward departures or downward. Our recommendation is certainly a lot more than the 2 years that Mr. Zerola is seeking, and I'm sure it's a lot more than his many supporters think he deserves. It's still significantly less than the maximum possible for rape, which is 20 years, as the court knows. I suggest that it's appropriate for this case. First of all, Your Honor, this was a different kind of rape than courts have traditionally and historically heard. And I'm going to ask, please don't discount this rape because it wasn't physically forceful. This wasn't a defendant who punched or choked or threatened or held down the victim. This is somebody who entered her home and then her bedroom and then her body, all while she was asleep after being intoxicated and physically ill in his presence not long before that. She woke up to being raped in her sleep. That's a different kind of trauma. It's a different violation of her autonomy. The law is clear that a rape survivor doesn't have to say no or resist physically, but Mr. Zerola didn't even give this victim the chance. She did pull away, ask him what he was doing, and tell him to leave when she woke up, but he had already committed the rape at that point. Commonwealth sentencing memo talks about aggravating factors, both according to the guidelines and separately. It's hard to talk about an imbalance between the defendant and the victim in this case without seeming to diminish her, make her sound helpless. Survivor in this case is an adult. She has her own life. She's trying to get her own company off the ground. She didn't ask for sympathy when she came in here and testified. I think the court could see that. Your Honor saw the only moment when tears came, which was when she actually recounted the moment of waking up to the rape happening. And as you'll see, she's not asking for sympathy in her impact statement. But she was helpless and most vulnerable at the moment the rape happened, and the defendant capitalized on a huge imbalance. We seated in this case, or the court seated with our input, impartial jurors who all swore before the trial started that the age difference alone would not prejudice them against the defendant. But the age difference is significant. She was 21, just out of college, barely legal to drink. He was 49 years old, experienced in social settings involving alcohol, involving drugs, which, as you know, were part of this case. Had the resources to pay for everything and have the whatever festivities were going on revolve around him. And also, more to the point here, he had experience in the criminal law of our state. I need to make clear what I'm not asking the court to do. Mr. Zerola cannot be punished for any past trial that went his way. If you take those out of the equation, you still have somebody who knows and knew at the time how these cases work. He advertised online his experience defending people against rape charges and representing sex offenders in proceedings to decide how dangerous they are and how they should be classified. Those are totally necessary and proper functions for a lawyer to do. But Your Honor can find that this defendant took advantage of that knowledge and the circumstances that led to this crime. The social situation involving drugs, involving alcohol, the paying for everything, the selfies laying down evidence of what was referred to at trial as flirting. It's kind of a nebulous and obnoxious term, but it was used a lot. Everything leading up that can be used later to suggest consent, willing participation, some kind of invitation. There was also the targeting of someone other than Mr. Zerola's dating companion at the time, a friend of hers, and then the defense that he tried to raise immediately after the rape to the woman, the friend that he was dating. Well, she invited me. She gave me her keys. She invited me to come back behind your back, pitting them against each other. Now, the defendant didn't get convicted of the greater offense of aggravated rape or the burglary, which would have required the jury to find a specific consent to commit rape at the time that he entered the apartment. But even if the decision to violate the victim didn't happen until he found her there unconscious, the same way she was when he left the apartment earlier, the court can still view his actions as calculated and as opportunistic and as preying on her. Defendant has submitted his sentencing arguments under seal. Sealing all of it might be a little broad, but that's not our battle. I will respect the sensitivity of some of the details that led to the request to seal, especially about Mr. Zerola's upbringing. I think I can properly respect that and speak generally and say that it speaks about a lot of trauma, a lot of damage. And Your Honor, by your sentence, in a way, will be deciding how much weight that carries. Where is a line drawn between explaining and excusing? And how is damage done to a person earlier in life balanced with damage that he's done, that he's being sentenced for? I also don't belittle the medical issues that have been mentioned on the record, but not in detail. There is no argument and there's no medical evidence here that the medical issues make incarceration impossible or an immediate danger. Mr. Zerola, as you saw, was an active trial participant with his lawyers, and he needed no special accommodations during the trial. And I also don't belittle at all the many letters of support that his counsel submitted and the people who showed up for him today. People are entitled to tell the court their experiences and their honest opinions about the person you're sentencing. Problem with that, Your Honor, comes if the court is asked to view this rape conviction not just as the only thing on his criminal record, which it is, but as an absolute aberration, something totally out of character, because character has many facets. I put a footnote in the sentencing memorandum that's in keeping with the case law that indicates that uncharged conduct, not acquitted conduct, that's a separate category, but uncharged conduct, so-called pattern evidence from the past, cannot be used to punish somebody, but it may be relevant for the court related to somebody's prospects for rehabilitation. I also suggested in that footnote that uncharged conduct might become more relevant if the defendant put his character or reputation in play. if it hasn't happened in this court for a while, it's kind of old school, but if somebody, for instance, testified as a character witness, then it would be permissible to ask him things like, well, did you know this, or have you heard about that, and how does that affect your view?
I do object for the record
Thank you,
to any
counsel.
reference to uncharged conduct.
I want to make very clear for this record, this court cannot, will not, and is not considering any acts other than the act for which this defendant is convicted in this case.
Understood, Your Honor. The only reason that was brought up, Your Honor, is so that the praise, which we accept as honest and heartfelt, that doesn't occur in a vacuum. You're looking at the total picture of the person. And only Your Honor can decide the weight of all the information, pro or con. And in the end, it gets back to what he did to the survivor in this case. She did not come to sentencing today. I don't think anybody can blame her for that, based on the attention the case has gotten, based on the courtroom atmosphere during the trial, both as it was like for her specifically and as it was generally. So please don't view her absence as any sign of apathy or lessened impact on her. She did ask me to read an impact statement from her into the record. May I do that?
I'm happy to receive that.
It says, Honorable Judge, writing this statement has been a profoundly difficult task for me. I pride myself on my resilience and have buried the events of January 2021 deep within my mind, locking them away, trying to forget them. I've tried to distract myself with studying and building my company. I wanted so desperately for this to be something that wouldn't affect me and not to give Mr. Zerola even a drop of power over the remainder of my life. However, participating in this trial and reflecting on the incident over the past few weeks has surfaced the significant and insidious effect this event has had on my life. For months after it, I experienced nightly recurring nightmares reliving the assault. Even today, I still have nightmares of someone breaking into my apartment and trying to assault me. I had never experienced a nightmare in my life before this. I've lost many nights of sleep. Since he committed this crime, I've experienced an extreme sense of paranoia. Every time I'm in my apartment, my door is deadbolted and I live in constant fear that someone will enter without my permission and hurt me again. Since moving to New York, I have lived in apartments I can barely afford just to ensure the building has a doorman, which is the only way I can feel slightly safe. This has financially strained me. Perhaps the area of my life most affected is my ability to trust people. I'm no longer able to trust others as I did before. I struggle to form new relationships. When I meet someone new, I research them extensively before allowing them into my life, even in the slightest way. I reverse image search my friends, friends of friends, and stalk their social media and internet presence, whatever I can find. I am paranoid. The morning after the incident, I was trying to figure out Gary's last name to tell the police who had assaulted me. I typed into Google the little information I knew about the man, Gary, defense lawyer, Boston. I was horrified by what came up, all the past allegations. I felt blindsided. I felt so embarrassed.
For the record, too.
Thank you.
So much for the letter that it references prior conduct.
Thank you, counsel.
I felt embarrassed that I had even associated with such a despicable man, even in the very small way that I did. I am determined never to let this happen again, which has led to my paranoia. Trusting men is particularly hard for me. I have developed a deep-seated fear and mistrust of men since this incident, making my dating life non-existent. It's hard for me to be even attracted to men anymore. I don't go on dates, have flings, or engage in any sort of relationships. I am extremely hypervigilant and scared. As much as I try to be strong and continue to work hard to prove this incident has little effect on my life, I fear I will be impacted by this for the rest of my life. Given that I'll have to live with this pain forever, I believe Mr. Zerola should receive consequences proportionate to the damage he has caused. I request that he receive the maximum sentence for his crime. Thank you. And she signed with her name originally. I can submit a copy that has the initials, Your Honor.
Yes, please. Do you have a copy with the initials with you?
I do, and I'll give one to counsel as well.
Thank you. I would ask that that be marked as an exhibit in this case. It shall be included on the docket in the record. It shall also be placed into the probation file as well.
Your Honor, I think with that statement, in terms of trying to put into words the damage this caused beyond the act itself, that concludes the Commonwealth's presentation.
Thank you, Attorney Pallenbaum. Attorney Krowski, I'll hear you.
Thank you, and good morning again, Judge Ames.
Good morning, Attorney Krowski.
As you know, there are three purposes of sentencing, and I know for you, sentencing is a sobering act. It's a powerful act. It's an act that affects not just the defendant, not just the victim in this case, but friends, family members, and the community. It has been articulated historically over generations that the purposes of sentencing, of course, are punishment, prevention, and rehabilitation. I have ethical limitations in discussing the case. Of course, at this juncture, we can state that we are disappointed by the verdict, but I can't question the factual validity of the verdict, and I don't want to do that, but I have to respond to some comments that the Commonwealth made, because with all due respect, I think it comes perilously close to questioning the validity of the inferential not guilty verdict on the aggravated rape.
You certainly understand that this court is not considering this as an aggravated rape, nor am I considering the charge of burglary.
I completely understand, and I know the court is well aware of that, and I don't mean to suggest otherwise, but the government creates a record. Even sentences are subject to appeal. So I just want to respond. You know, the reference to the three specific things. One, the fact that Mr. Zerola is a lawyer. Mr. Zerola served a constitutional duty representing clients, including clients charged with rape and other sexual offenses. I, over a 25-year career, have represented too many defendants to count that have been charged with like or similar offenses. But my status and Mr. Zerola's status as a lawyer affords him either no more or no less discretion before this court when you engage in your constitutional role of sentencing. I think it is factually and legally erroneous to suggest that because you're a lawyer, you somehow become automatically subject to the inference of an aggravating circumstance, that Mr. Zerola, because he was a lawyer, somehow put in motion a consent defense when that night began. And I think this is where the Commonwealth crosses a line, because the not guilty on the aggravating rape suggests, and the only legal real import of that is that Mr. Zerola, the jury found, did not have the intent to commit a rape at the time he entered that apartment. There was also, and I am not engaging in victim blaming or victim shaming, but the SJC has articulated that we have a role to zealously advocate for our clients. So the suggestion that Mr. Zerola somehow used alcohol and drugs as a method or manner to put this in place also is belied by the record. And again, just to respond to the government's argument, the record was replete with instances where Ms. Bidek, on her own, absent from Mr. Zerola, had been drinking, had been consuming alcohol, had been using cocaine almost constantly over a period of months. So this is not something that Mr. Zerola introduced or used or applied Ms. Bidek with. And the other thing that they seem to attach great significance to is the age gap. But that age gap has really no legal significance. There was no statutory significance to the age discretion. The fact that Ms. Bidek was 21 and Mr. Zerola was 48 might for some people be unpalatable or not optically pleasing, but it does not fall within any of the parameters of something that would warrant an upward departure from the guidelines. Now, let me speak about those guidelines. Great care, great time went into the drafting, the implementation of those guidelines. They closely monitor and mirror the language used in the federal side, and the federal side is helpful because there's been United States Supreme Court review in United States versus Booker. And essentially what the court says that although the guidelines are not mandatory and binding, they are and should be the first place that the court starts because they promote the purposes of sentencing, as I've defined to this court, punishment, prevention, and rehabilitation, but they also are a way of treating defendants similarly situated alike, so that there's not a wide gap and disparity in sentencing. One of the things that the guidelines do ask the court to look at is the history and characteristics of the defendant. Now, I appreciate the Commonwealth not getting into too much detail, but I have to get into some of the detail. The reason I filed that motion under seal is because prior to today's formal setting, I didn't want access to that information to be used.
That's your prerogative,
Yes.
counsel. You may say as much or as little as you like.
Mr. Zerola doesn't use it as a crutch. Mr. Zerola didn't urge me to use this information. I use it as his counsel because it doesn't excuse, but certainly explains, and certainly it's something that the court should, pursuant to the guideline, take into consideration. Mr. Zerola is the youngest of 7 children. I would say that he certainly is a brother. I would say that he was a son, but he never really was a son in childhood. He was nothing more than someone unplanned that was probably brought into this world, was disposable, was uncared for, was unloved, and was at oftentimes, like the stories submitted from at least one of his siblings, and for the other siblings, they all support him, but it was too painful for them to even submit something in writing. My client was born to Frank and Lucille Zerola. Frank Zerola ran an insurance business out of the family home. Frank Zerola used his family, all of his family, as essentially nothing more than a punching bag. There was a story recalled from my client's brother. I don't want to put his name on the record, but you have the letter.
I've read them all.
Where he was seen mounting my client's mother and with clenched fists repeatedly struck her over and over and over again. Life was so bad for Lucille Zerola that in front of the children, she took out a gun at one point and shot herself. Frank Zerola's response to that was to laugh. Those kids who really had nothing in their life and lived a life of fear, with the exception of one of the brothers, life for him as a 10 or 12-year-old was exciting that he would be able to go down to a convenience store and buy cigarettes and alcohol for the alcoholic mother who was home in bed because he got to keep some change, sneak some change on the side. The siblings kind of united together, and at one point, they thought it was a good idea, and they were surprised to rescue a stray dog that they had found. They brought that stray dog home, and rather than accept it and for once, just once, give that family a pass, Frank Zerola brought that dog into the basement and in front of all of the Zerola children, shot and killed it. This is the background that Gary Zerola comes from. The fact that he was able to put a life together is nothing short of remarkable. He did meet love and affection in his life. Mildred and Richard Bowes. Richard Bowes was well known for being a Senate counsel to the Senate for 40 years. Mildred Rose was everything that Lucille Zerola was not. Prior to them meeting him, and you saw some of the letters, one of the letters that jumped out to me was from a John Gallard. he would see Mr. Zerola in the neighborhood walking with shabby, torn-apart clothes, but carrying a bag, trying to earn money, carrying some of his friends' books to school for them. Even at that age, without any guidance, he always had a keen mind and a desire to read and learn and better himself. And that led to the Bows, and that led to what appeared to be a life. Mr. Zerola was ultimately able to get into Suffolk University and Suffolk Law School. He was the only one, and I believe it stands true to this day, that gave the commencement speech at Suffolk University as an undergrad and at Suffolk Law School. He graduated with a dual degree, a master's, and I believe management, and his JD. He immediately went to work. The day after he obtained his law license, he argued a motion to suppress, and his opportunity and his future seemed limitless. And again, without making an excuse, but the law and the science recognizes it as a mitigating factor, the damage essentially had been done. Mr. Zerola clearly never forgot where he came from. He made it a lifelong passion of advocating for kids like himself, foster kids. Something I had omitted is that Mr. Zerola's older siblings were old enough to escape the house of horrors that they had lived in. Mr. Zerola was not able to do so. He was the youngest one, and at least a dozen times he was sent back to a house that was nothing short of horrible. When he ended up coming into some means, he was one of the first charitable organizations he started was a Cause for the Kids, and that dealt with raising money. Him and his brother proudly raised money for foster kids, giving them clothes and gifts during Christmas time. He was recognized by then Superior Court Judge Locke, who was the head of DCF at the time, for his outstanding work to foster kids. He was a sought-after speaker, went all over the country, always on his own freight, never took money paid to go and speak and to try to give promise and hope to other people that had been in his situation. Likewise, Mayor Menino recognized the good and hard work that he had been doing. He received the Boston Neighborhood Award from Mayor Menino. He also, with a Boston police officer, Andrew Biggio, started the Boston Wounded Veterans Charitable Motorcycle Run. They raised a lot of money for veterans that had been wounded. I know you have the letters. I wanted to make a quick comment on that because and I don't mean to suggest that the government tried to assert a negative from it, but irrespective of someone's past, the court should consider whether or not there will be a support network, and there is. And this is a support network that Mr. Zerola has earned over the course of his lifetime. These people didn't just show up for the heck of it or because they had nothing better to do. You might recall a letter from a Robert Walsh. Robert Walsh had a conversation with Mr. Zerola one day, and he had mentioned to Mr. Zerola that friends of his that Mr. Zerola didn't know had no home heating oil. And Mr. Zerola, without any prompting, paid the bill for the home heating oil. Now, Mr. Zerola didn't do that because he thought someday that would help him before Judge Ames at a sentencing hearing. Mr. Zerola didn't send out press releases regarding that. And that was only one out of thousands of similar acts. Mr. Zerola did it the way it should be done, silently, because it was the right thing to do. I can tell you, as early as this morning, I was telling people that Judge Ames is a stickler for deadlines. The deadline has come and gone for the sentencing memo because I was still receiving letters. I don't want to hyperbolize, but I'm probably at about 100 letters right now sent in support. And these come from all walks of life. These comes from...
Counsel, if you wish to submit further documents, letters, or anything else, I'm happy to receive.
Thank you. I knew that you would probably, knowing that you're diligent, had read the memos. I didn't want to be sending things at the last minute because I didn't want the court to think that I didn't take your deadline as serious. But the point being is, sure, some of these are clients that he skillfully got out of harm's way, but a lot of them are clients that came to him and said, I can no longer pay you. And Mr. Zerola, I've never come across a client where he filed a motion to withdraw because money became an issue. There are neighbors, there are people that were friends with his mother, is of failing health. She's too old to come, but one of her sisters has been here every day, and Mr. Zerola refers to her as his mother. And these are people that he has, again, earned this with. So that's certainly something the court should consider. The court should consider not as a negative, conversely, as a positive factor, Mr. Zerola's age. And I'm going to say a little bit more about that like this. You know, when you're trying to formulate what an actual number is, and you do not necessarily a quantitative, but a qualitative analysis, there's really two ways to do it, right? You can assign each day a unit, and there's two ways they do it in mathematics. One is they call it a constant, but two, they call it a variable. And I'm asking you to consider it as a variable. And what I mean by that is not every day in prison, incarcerated, is the same. Not every day that Mr. Zerola is presumably going to serve, because we haven't even asked for probation, is going to be the same. But if you extend that argument, not every prison day is the same for every person. And what I mean by that is if you were a 25 or 26-year-old with a clean bill of health, and you were being sentenced to prison on a drug or gun-related offense, that is still going to be a very difficult time. I go to these prisons. I've never served a prison sentence, but I hear the stories. I see the stories. Prison, despite what some people might see or read or hear, is a very difficult place. It is a violent place. It is a scary place. It is a psychologically traumatizing place. Criminals are not coddled, and I don't care what any member of the media says to the contrary about that. So as difficult as that would be for someone, say, 25 or 26, that's going in on a gun offense, think of how difficult that is going to be for someone who is 52 years old, and let's not ignore it, going in convicted of a sexual offense. Mr. Zerola, I didn't know him when he was 25, but certainly is now 52 years old. You know from the pleadings that he has significant health problems. He is suffering from a rare and aggressive form of eye cancer, ocular cancer. And Mr. Pallenbaum, and I don't think that he did this nefariously, but suggested that there will really be without limitation his treatment. That couldn't be further from the truth. Mr. Zerola sought and received treatment in Massachusetts for his eye cancer, and despite having some of the best and brightest people in the field in the entire world, even they said it was too rare for them and they didn't feel comfortable because they didn't have enough experience treating it, so they had all recommended and referred him to Dr. Shields in Philadelphia. Now, you know, Judge, that he had went and saw Dr. Shields, and Mr. Zerola did not want to further delay the trial for anyone, and we didn't press after the court was gracious enough to let him take that appointment to seek any further delay. But Dr. Shields, although certainly while she confirmed the findings that the surgery was not successful, that cancerous malignant tumor remains in his eye, and she did cite some growth, but not, overnight growth, still her prognosis is fairly dire, and the recommendation was for Mr. Zerola to go back to Philadelphia as soon as he can. Well, I don't presume to know what sentence you're going to give him, but I know that that is not realistic. And despite the people at Shattuck that do their absolute best under very difficult circumstances, but if Dana-Farber and Mass General and Boston Medical and all these places couldn't handle it, I don't believe that the people at Shattuck are going to be equipped and have the experience in training it. And make no mistake about it, it could be fatal. So certainly that's something the court should consider, and that I would ask the court to consider as factors reducing the potential sentence from the guideline. Now, I had some concerns about the Commonwealth, and this is not a personal shot, but look, that there was some, perhaps if not expressed, but implicit bias against Mr. Zerola. And that was probably confirmed when I saw the government's recommendation. They're asking the court to go, by my rough arithmetic, 84 to 85% above the guidelines. Their recommendation, the guidelines are 60 to 90 months, 5 to 7 years. We've asked for a 2 to 3 because he has no record, because of his age, because of his health problems, because of the strong support for the community, and there's a couple of other factors I'll discuss. But they've asked for an increase to the guidelines, an upward departure, based on nothing more than really a repetition of the facts of the case. And what I suggest to you is when the guideline committee contemplated what was appropriate, this falls, if ever a case called out for a guideline sentence or below, this is the case. There's no better way to say this. No rape is good. And so while I don't minimize that, what the jury found, that Bella Bidek, and again, we can't, and I agree with the Commonwealth, we can't parse out or extrapolate exactly what they were thinking. We don't know if they found that she was actually awake, but the stupefaction instruction had some credence to it. We don't know. But we do know that no rape is good rape, but the allegations, to the extent that they were proven in this case, certainly don't distinguish them from another type of rape, a rape where perhaps a woman is accosted in an alleyway, or a woman is forcibly raped and suffers beating during the rape. So there's nothing unique about these facts that would warrant such a departure, and it actually cuts against all of the work that the Guideline Commission did. To the contrary, and I don't think age should play a role, but to the extent, again, there is optics involved, if there were 2 college kids in a similar circumstance in this case, I'd probably be asking for house time. Now, when we talk about, one other thing I wanted to talk about is rehabilitation. Certainly there was evidence of alcohol use and drug use by Mr. Zerola as well. And that's something that the guidelines talk about the court should consider. Mr. Zerola has been on conditions of release since the inception of this case for the better part of 3.5 years. He was outfitted with a scram device, and he was required initially, I believe, 4 times, and it was reduced to 3 times when the medical issues came up, to have his blood alcohol content or his, through sweat, whatever the scram device monitors, tested. Probably estimating about 3,000 scram tests were performed, and not on a single occasion did it detect that Mr. Zerola had consumed even a sip of alcohol in 3 years, which shows that he recognized the seriousness of the offense that he was charged for. He recognized that a judge, and I don't believe you set the first conditions, but that it was an order of a court he had to follow, and he followed it. And he followed it to a T. And certainly, DOC has done a much better job in getting progressive with addressing rehabilitation. I know, again, anecdotally from other clients, there is now meaningful opportunity for him to afford himself of all kinds of counseling. Obviously, with his degrees, he doesn't need the vocational training. He would take it if he could. They'll probably have him be a teacher. But certainly there is dual diagnosis, there's substance abuse, drug abuse, alcohol abuse, anger abuse. There's as much programming as the person wants. And knowing Mr. Zerola, he will be ambitious about it. He will be vociferous about it. He will be prolific about it, and he will do that. But the point being is the court has a pretty good body of evidence over the past 3 years that you're outfitted with a bracelet, you're on home confinement, you cannot have a sip of alcohol, and he's done it. And I know that I've talked to his probation officer. He is dutifully reported in person, by phone. He's coordinated with them the medical treatment, everything he was supposed to do. So there's a pretty good history that he knows he can't drink. He knows rehabilitation has to be part of the process. So we've recommended 2 to 3 years sentence, and I circle back to where I started. 2 to 3 years is going to be exceptionally, and I know his family members probably don't want to hear this, 2 to 3 years is going to be exceptionally difficult and dangerous for Mr. Zerola. He is going to probably, on a daily basis, have to deal with comments, some of them on the threatening side. He probably, on too high of a frequency, is going to have to deal with physical confrontations. And he's going to have to survive. He's going to have to survive the cancer, and he's going to have to survive for the charge for which he stands accused of. The parsimony principle is something that's been recognized in federal court, and I believe in language, Rodriguez and some of the other cases in state court, that stands for the proposition that a sentence should be sufficient but not greater than necessary. Again, every day is difficult. I respectfully ask that you sentence to Mr. Zerola to no more than 3 years, no less than 2 years in state prison. And I know it has no legal binding authority, but I ask that you recommend Norfolk because I believe they probably are the best equipped medically to deal with patients that have serious conditions.
Thank you, counsel.
And my client, one last thing.
Sure.
I don't want and I know your experience, you won't take it as a lack of contrition. Obviously, with a pending appeal,
Yes.
Mr. Zerola cannot get up and make any type of statement. And I know you know it. You've been doing this for a long time, but I have to say it. Please don't mistake that for
I
a
was
lack
going
of
to
contrition.
ask you if he wished to allocute,
He does, but I've advised him that he cannot.
and that is not surprising, and this court, it's probably a very prudent step. And I understand that that doesn't mean that he doesn't wish to speak, but at this point with an appeal pending, ought not to speak.
Thank you.
Thank you very much. I have read very carefully and repeatedly and considered the memoranda of the Commonwealth and the memoranda of the defense. I have now listened very carefully to the statement of the victim in this case, and I have read more than once the letters of support, particularly the letter of the brother that laid out the circumstances of Mr. Zerola's life. I have also considered the acts and circumstances for which he was convicted in this case. It is this court's judgment that a sentence of not less than 5 years, not more than 10 years, is warranted by these facts, and the court imposes a sentence of 5 to 10 years in this case. Madam Clerk.
Thank you, Your Honor.
No, impose everything.
Okay.
Please.
Judge.
You're welcome.
Mr. Zerola, as required by statute, I must inform you that the records regarding the charge for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court, unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you must use the request not to seal form. A copy of that form has been left with counsel at defense table. I cannot accept the form here in court. You must submit that to the Commissioner of Probation at the address provided on the form. Please be aware that if records regarding the charges for which you have been found not guilty are sealed, you'll be unable to access the sealed records of the not guilty disposition or any records regarding to those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request those copies from the court within 10 days. Do you understand that, Mr. Zerola?
Yes, Madam Clerk.
Okay.
The record shall also reflect, and then I'll give you a chance to impose the sentence, that it is the court's recommendation that the sentence be served in Norfolk County. Go ahead, Madam Clerk.
Mr. Zerola, the jury having returned a verdict of guilty as to indictment number 2184 CR 00072 to offense 001 to the lesser included offense of rape, the court sentences you today to a term of not more than 10 years, not less than 5 years. That sentence to be served at Norfolk at your request. The court is imposing the DNA fee of $110, as well as the victim witness fee of $90. You're being notified that pursuant to Rule 64, you have a right to appeal this sentence to the appellate division in writing within 10 days, and that's pursuant to Rule 64. You're also being notified that you have a right to appeal the conviction within 30 days pursuant to Superior Court Rule 65. You'll receive any credits to the sentence during predisposition. You stand committed, sir.
Mr. Zerola does thank you for your thoughtful consideration.
Thank you very much.
All rise.